Good morning, everyone. Welcome on behalf of the Fieldfisher Global Investigations Team to this seminar about technology in investigations. I'm delighted that we have been joined by clients and colleagues, both in person and online. And I'm also delighted to be joined by our friends from TransPerfect Legal Solutions. It's no secret that we have worked with TLS for a number of years and have first-hand experience delivering cutting-edge technological solutions that benefit our clients in the context of our investigative work. Al and his team will be talking today about the evolution of technology in the investigation space, looking at what has come before, where we are today, what we might expect going forward. I should say that this session is designed to be interactive, so as I understand it, there will be some pauses, opportunity for questions, opportunities for people to share their experiences. For people who are online, clearly that's a little bit more tricky than people who are in person, but please do feel free to put comments, questions in the chat box, and we will be monitoring those and seek to raise as many of those as possible. We should be wrapped up by about 10 o'clock to give everyone the opportunity to get back to their desks. And for those who are in person, please do feel free to stick around if you'd like to. For those online, sadly, we will have to say goodbye to you then, but please do drop us a line if you'd like to talk further about anything that we discussed during the course of today's session. I think without further ado, Al, I'll hand over to you.
Sure, thank you very much. Good morning, everyone. Hopefully you can see us. I thought just very quickly, Ship's been very kind with his introduction. TransPerfect has been around for 30 odd years. It started as a translation company in New York, but the clients that we had early days were law firms. And so our CEO and our management team invested in technology very early into that journey. And so we have a number of proprietary tools, we have a number of licensed tools. We try and stay ahead of the curve. And more recently, I think, and this will come out as we speak about it more, we've invested in the people that run the technology. I think tech's becoming much harder to ignore. The lawyers, the businesses, the tech is becoming more complicated. It's not plug and play. And so we spend a lot of time there's an EY before, there's legal analysts, researchers like Ruben, to try and deliver that service and also upskill the lawyers that we're working with. At the end of the day, the more the lawyers can do themselves, the better for their clients. And I think we've enjoyed working with Clinton and Ship for many years because from the very beginning, they have been open about using technology. They're very humble about using different types of resources, keen to learn. I think it's why clients have benefited to a huge degree. I think when lawyers are really invested in the tech, all it does is augment their ability. It doesn't really replace what they do by any way, shape or form. It simply helps them deliver better services to their clients. So we're going to do this in kind of three parts, just run through where technology was, is, and kind of in getting to in the legal space. And then a case study that we've worked on together, kind of in nebulous terms, so we're not giving away any information, but just looking at how that works in practice. And then Quinton particularly was keen on having some videos so that the audience can see what it looks like in practice. So hopefully those work, and if they don't, maybe we can have them out together. So we're going to go through some of the pieces of tech that maybe you're all familiar with, whether it's tablets, papyrus, ink, really what a lot of tech in the legal space has been developed in tandem with is just communication. And so as communication tools develop, that's really what the legal industry has been tracking. I mean, at the time of pen and paper, arguably lawyers were at the forefront of technology, and now we're all Luddites and get accused of wanting to retain the hourly rate and not entertain that conversation. I think when I gave a similar presentation a couple of years ago with you guys, and I dug that out, and actually the slides that we used a couple of years ago ended about halfway into the slides that we have for today. And so there are still a few more that we had 2 years ago. We weren't using fax machines and the like. But I guess the thing that goes through all of this is that at every juncture, society first and foremost underestimates the change that will come in 10 years, overestimates it in 2. People just don't like change, lawyers more than anyone. And there's been a successful advisory model in our industry for a long time, which makes us even more reticent to change. I think that the tables are turning now. We were just having a conversation over breakfast. I think that lawyers are going to end up safeguarding the evolution of technology from this point forward. A lot of what is happening in the world of artificial intelligence actually comes back to the ethics, the ethical framework under which that AI is being developed. I think lawyers are in a very privileged position to be able to, if they understand the technology and want to engage with it, to be at the forefront of that change and make it responsible. So this is kind of the natural pause in the evolution of tech. These are just 2 good quotes that I heard a few weeks ago in internal conference. So you have less in, and I did some research on this, it wasn't nonsense. You have less in common with an average person from the year 2123 than a Roman citizen from the year 23, even though the future person's 20 times closer to our timeline. And anyone that knows about tech, there's an exponential curve, so things tumble along very slowly, and then all of a sudden you see that growth in a very, very short space of time. And that's fairly terrifying, because what that means is all the nonsense that we saw before about tablets and pirates, that's actually probably more modern than the Romans, and that's what we have more in common with in society than 100 years from now. The second is from, he was the youngest senior vice president for SAP back in the day, and is probably the best keynote I've ever seen. Many grown men and women in tears talking about technology, which is very hard to do. I'm hoping for a few laughs, maybe some tears today, but I can't see it happening. And actually, he was writing a fairly humanitarian piece about protecting society from artificial intelligence. When I read this, I looked at it the other way. So tech execs in suits take pride in promoting the idea of how technology like AI is good for the world and how growth will be inclusive, even though the data shows that powerful tech tools will make the best people even better. And so to me, that said that actually this is a huge opportunity for the best lawyers and the most sophisticated organizations to engage with AI and technology. They already have everything. They have the raw material to make the most of that tech and vice versa. We see this often, that the typical workflow is that you will have a paralegal training up the machine learning for a review tool. When a partner, we have some firms where partners might engage in that process for 5 or 10 hours. The training of the technology in that 5 hours is probably 10 to 20x of what a paralegal gets done in 50 hours. And so I think the legal industry has been very scared of technology, first and foremost because it eats into the profitability model. I think that model is dying and will be dead much quicker than people want it to be. And all of a sudden, technology then becomes a profit driver rather than something that hampers the ability to grow. I think that the organizations that law firms serve, they're already using this technology. They have been for a while. It's the lifeblood that flows through their organisation. And so the expectation is, whether it's for litigation or arbitration or investigations, that we should be using these tools to interrogate the data that underpins the ability to advise. So these are maybe slightly more modern pieces of tech. Objective coding is when you take hard copy documents and digitize them, which sounds very simple, but we had an investigation in Africa where a lot of the documents pertain to mines. So they different from touch, English.
I don't think
hundreds of thousands. But then also having the experience to some of there's always that what it really does is take huge boxes of documents that many of us probably spent putting post-its on back in the day and doing that electronically. It allows you to organize those documents and then plug in things like the ability to listen to audio or review video and tag it. I think this is around where we got a few years ago. Brainspace, which we'll look at in a bit more detail,
I'm totally on your side.
Has a little bit more AI-leaning technology in it. Really, it's kind of cognitive computing, conceptual analytics that allows you to build trends from data that can help inform legal strategy or maybe now is the tech can do things that even an army of 100 lawyers can't do with 100 days. Brainspace is a very good example of that. Digital assets have been in the press and the legal press an awful lot recently. I think there's a company called Chainalysis who they help digital asset theft analyze where the digital assets are going. But they reckon that last year about $4 billion worth of digital assets were stolen, and that's from reported numbers, double, triple. And so from a legal tech perspective, there's a lot of safeguarding in place where you have institutional investment in crypto or NFTs, which is great, and those things are held offline or in secure wallets. The bigger issue is when it happens. Prevention's great, but most of the time we're dealing with cure in what we do. And so having companies like Chainalysis who can go out there and use timestamping and public records to try and find the identity of who and where digital assets are moving. There was like I said, proceedings by NFT drop last year. When I was a junior associate, we actually were the first firms ever set up proceedings like Facebook. And then actually one of the big things that's happening in digital assets is that the regimes are very different. So the lawyers, they're really leading the charge on that. So there was a case last year where here the court said digital assets were property, which then allows you to regulate them under an existing construct rather than recreating law. In the US, it's slightly different. There are fights between the SEC around whether it's a currency, a security, or a commodity. And actually, we had a conference 3 or 4 weeks ago in the antitrust space where we had Lord Justice Nicholas Green, who's the chair of the Law Commission, speaking. He was saying that one very interesting thing is that there are no real international boundaries for digital assets, and it gives us here puts us in a very strong position for any arm of legal practice, including investigations, because the law around the thinking behind the law on digital assets, again, can be globally applied. So there's a decision. He's the highest bankruptcy judge in the US, in New York, and he actually referred to the UK Law Commission's paper on the regulation of digital assets, because he just said it was a more sophisticated way of looking at it. So where we have a regime that that has a bit more certainty than other places in the world. Everything that stems from that, whether it's an investigation into it, whether it's actually getting a Norwich farm account or something like that, we're in a place here that maybe some other jurisdictions are not in yet. I'm probably going to talk for like another 3 or 4 minutes, but if you have questions, by all means stop me. I can talk for 5 hours on this, but I've been told that everyone has better things to do. This is one that I know we talked about, but polygraph technology. So we wrote a white paper together, I think around COVID time, right, on remote investigations, where everyone all of a sudden had to go from, locking the subject of an investigation with the dark room with their lawyers and everyone else involved in getting the truth out of them, to having to do this remotely and drop off. There's the famous Moravian model, which like 70% body language and 20% information, somewhere around that. And so you're losing a lot. I mean, the technology already existed, but people started using it for remote interviews and witness evidence. Where that very quickly went into was that some of that tech also includes the ability to use advanced lie detection tools. So whether that's facial nodes, they have tools that can sit on your eyelids, which they can't detect the eye flutters when you're lying, apparently. You put people in MRI and get a very good sense of whether they're being honest or not, which may be impractical. But these things, and we kind of talk about the future, but most of these things are happening. So this was used by CAS last year in a case called Villanueva, where they permitted polygraph evidence of a witness. And so one place, I think, investigations has even more flexibility than something like arbitration, which is procedurally more flexible litigation, is that you're not really subject to as specific a regime as you may be in other parts of the law, kind of subject to what your internal processes are as an organization. And if there would be hurdles to overcome if you wanted to hook up your employees to polygraphs, no doubt, but they may not be insurmountable to do this in the High Court level. VR and AR, so we're already seeing this a lot in the construction space where people are using AR to get into like the CAD drawings and designs of buildings, so you can actually all sit together and you can move the model around. VR, people tried this out towards the end of COVID, using things like the metaverse to do witness interviews. It didn't go that well, but the larger part of society is kind of moving in that direction. So the legal industry tracks it in ways. I mean, we're developing a VR type solution for remote contract lawyers at the moment, where you can basically walk around and see people's virtual screens inside the platform. And one of our senior guys in New York really likes it. I mean, I don't know whether clients will engage with it, but remains to be seen. I think the reason why is because there's other tech out there that maybe achieves more in an easier way. And so we're asked to speak at a conference in New York about tech and applying on the use of holograms in witness evidence, which we had to slightly decline because I've never done it in practice. But as I've looked into it, the reasoning behind it makes a lot of sense. So it ticks even more boxes than maybe VR and Zoom Teams on that Moravian model. They're pretty realistic, so you're getting the body language, you're getting the intonation. I think, and again, when I mentioned this to Quinton Ship, they speak but they thought that actually this is a better solution to doing things like interviews and maybe other tools that are out there. The one caveat to that is that this one looks fine. The company that does called Proto, but the life-size rendering is fine, but they also have desktop holograms, which I looked at and they just seem very, very strange and comical. So I can't imagine the judge having a mini-me on his desk doing evidence really working. And then decentralized dispute resolution. So we're seeing a lot of platforms come up that sit outside the parameters of what we would understand as dispute resolution. So there are a few where you can be judged by a jury of your peers, but those peers have to buy in with Bitcoin, for example. Justice is very swift, which everyone wants. But also the bigger one is around enforcement. When you're looking at digital assets, if you subscribe to a platform like that, there's no question around enforcement. The digital asset can be transferred automatically on a decision. They're pretty rudimentary now, and I think last year the biggest platform had about 2,000 disputes through it, but they're all kind of quite small ticket because there's no expertise overlaid. But some of the work I do with the Ministry of Justice on digital assets, there's a desire and a lot of expertise, particularly in the US, to kind of overlay that with some high-level crypto specialists that sit as a human intermediary to a platform like this. And then, obviously, AI. Some of the things we've already talked about, how to build things, so the machine learning in some of our review tools. But there's not really any getting away from artificial intelligence. We already see it used in things like in continuous active learning and brain space, but more widely in the industry, people have been using it for things like arbitrator selection, where you put in all the information you have on various arbitrators in various different jurisdictions, and it will spit out a recommendation of where to maybe bring the arbitration. It's been used in predictive justice. None of these things are going to be relied on in isolation. I don't think that's the plan. I don't think it will ever be the plan. But the one that now, I suppose, has everyone's ear is generative AI, which is fairly terrifying when it's unpacked. What it can do and the time in which it can do it is scary. And so again, it's one of those things that I think lawyers have to really get a saddle on, understand and control the development of. So A&O, who are pretty tech progressive, they have things like Fuse, which was their incubator program for legal tech startups. They're a big enough firm that they have budgets to invest in tech. One of our colleagues who just joined us a few months ago from A&O is still quite connected to the firm, and he was part of the Fuse incubator program. The reality is that a lot of that stuff is for marketing purposes, and it's for brand building. I think the best thing that ever happened to that program was Facebook came and bought one of their incubators from their nose, which wasn't great. But he was speaking to some of the people who said that Harvey, so for those who maybe don't know, A&O did a deal with OpenAI who make ChatGPT to bring Harvey on as a kind of a module, a legal specific generative AI module for the firm, and they had about 3,500 lawyers use it, 50,000 queries to start developing it. The body of information that's available open source in the legal space is huge. And what our colleague was told is that in the space of 2 months, more people have interacted and actually then used this technology than everything else put together that's been tested. And the output is phenomenal, like the research notes, the drafts, even things like procedure. It can look at how to make the procedure more efficient. Nothing's going to go out of the door without someone reviewing it. But as I said at the beginning, this is really about augmenting legal process, speeding up what lawyers can do. And then check that. A very simple example is that we have an automated redaction tool. It probably takes seconds to work, but the QCing the redaction that's been automated is 10 times faster than a human being redacting. And when you think about that, something like research or pleadings, or an arbitrator's decision or the report from body of evidence for an investigation, the best lawyers are still going to generate the best stuff by post-editing what the AI spits out. They're just going to do it way more quickly and way more efficiently. So I'm going to pause there because we've got a case study. I know I was going to ask, well, first Principal Chip, but also Ellie Kirsten's on the line, because there are some pretty serious data privacy, transfer protection issues around all of this, but particularly tenants. So if either of you want to go ahead, or we can take Kirsten on one of the speakers.
Kirsten, do you want to come in on that point first of all, and then we can perhaps touch on some of the topics that I was opening? Perhaps we'll do it another way. So perhaps I'll start with observations and
Hi, Rod.
So I suppose the first point, and it's not is just in terms of some of the things we go through that already and your initial reaction to it. So if people were honest, who when they saw the idea of a hologram with the actions, well, is it possible? And I think we all have these instinctive reactions, and I can remember there's a big war story being a criminal bar in the Northeast when it was proposed for the first time that there was digital case management systems where all the case papers, instead of being delivered into pigeonholes, but actually going to be exclusive. Allowing your staff to in chambers, and there was a huge reaction to that. And many forces of art. It's unworkable, it's not going to happen. It's simply not workable. And of course, now we have fully electronic courts where case papers are a thing of the past, and even the senior judiciary, I say, are well used to working electronically. So I suggest that we've had that sense with things like technology assisted review already. We are going to react to that, really, when we hear about evidence by hologram. The history shows that actually there is an undeniable issue when it comes to technology and investigations and courts litigation. And I think the sooner we all accept that reality and start to engage with them and become knowledgeable about it, only be a good thing. Now, touched on points already in terms of private practice stories. We have clients already who are incredibly sophisticated and are using artificial intelligence and these sorts of systems in-house. So we, of course, need to adapt to that. And it's not okay anymore for a partner to say, well, yes, so the document population is 3 million documents, so we're going to have an army of 20 paragraphs to review all of those documents for privilege substantive. It's not acceptable to clients anymore when we come to internal investigations in particular. Of course, when we're talking about full disclosure, we have to be careful about these distinctions. There are other considerations at play, so we still have to bear in mind the various obligations in court when we're at that stage. But to Al's point, where fundamentally we're dealing with, we need to work out what's happening, why and when. And we need to get quickly to a point where we're making important decisions around remedial actions. Actually, the use case for AI is undeniable. And I think just to give some illustrations, we've dealt with internal investigations. So we had an internal investigation by one example in Ecuador. We had a document population of 500,000 documents. And for various reasons, we have real time constraints as to when the meeting to take place and when we need to reach conclusion in that investigation. With traditional page turn review, the reality is it would be possible without exponential cost of time, and probably we would never have got to where we needed to be. So we leveraged AI. I think we ended up reviewing about 15,000 documents using technology assisted review. And we were able to give ourselves and the client confidence by reference to the relevancy scores, which of course you use in the relevant software, but actually we had hit, we couldn't say 100% of the relevant documents. Of course we could give a high degree of confidence that we'd seen the material we needed to see in order to produce a competent and useful investigation for the client. Similar case, I did an investigation into a project in South Africa, 3 million document population, again under time pressure with cost constraints from the client. we were able to whittle down that document population to 62,000 documents with more traditional search methods. And then we leveraged technology system review for the purposes of that document review. So I think in that case, because we already had a pool which was by definition not relevant, we ended up reviewing about 60% of documents in that pool. So again, the cost savings for the clients and the efficiency savings was huge. Chip, do you want to pick up any other points? Okay. Kirsten, can you hear us? And are you able to come in on that data protection point?
Yes, I think I can hear you now. It's a little bit faint. Yeah, so from a data protection perspective, I think you always need to bear in mind that still the fundamental requirements of data protection are going to apply. So, you've got a lot of information to sift through, and there could be a lot of personal data in there as well. And that definitely with sort of when you're carrying out any sort of investigation, I would recommend carrying out a data protection impact assessment, because then you're going to go back fundamentally to the basics and think about, have we actually got a lawful basis for processing this data? Are we potentially going to find information about criminal offences or special category personal data? What are we going to find using these great tools that are available to us? And have we got a lawful basis for processing it? And then, if you think that you have, then you can document how you're going to go about jumping through all of the data protection compliance hoops. And it's good to have it documented in a data protection impact assessment before you start using these tools to process data, just in case a regulator ever comes along and asks and said, did you think about all of this stuff? And you can wheel out your data protection impact assessment and say, yes, we did.
I actually have a follow-up question to that. So for a lot of the work we do, where we're maybe transferring out of the EU or the UK, and we have a DTA in place and we have the SCCs, we use what was the old derogation in GDPR 49(1)E, where you can expatriate data for the purposes of legal proceeding, which I think is now contained in the SCCs. For investigations, where you have data that's in the EU and needs to go out, or you have it in a jurisdiction where the regime isn't clear, what do you usually use as a basis to transfer it? Or, like we did in one of the ones we worked on, would you just try and do everything in country?
Yeah, quite often the first port of call, if possible, is to do it in country, because you're quite right. It is much more difficult nowadays to transfer personal data outside of the EU and the UK. That's since the Schrems decision, which brought down Privacy Shield and brought in a whole new layer of protections for personal data. So the easiest is to keep it in country. That's not always the best solution for the investigation, though. So if you are going to transfer the data outside of Europe or the UK, then usually the way that we would do it is rely on standard contractual clauses and carry out your transfer impact assessment to check that you've got the right security measures in place as recommended by the European Data Protection Board. And just picking up on your point about the derogations, so there are some derogations around transfers of data outside of Europe, but they are really intended only to be used for sort of occasional, it's low-level data transfers outside of the country, not really for big bulk data transfers of data. And also, you have to be very careful that you stay within some very confining parameters for those derogations. So, what might be necessary for legal proceedings isn't necessary for your investigation itself. So, yeah, you have to be very careful when relying on those derogations.
Thank you. And our recommendation is usually assigned down to risk and cost, because we can do the whole investigation from start to finish in country, but if it's a country where we don't have data center, then we would have to bring in a mobile unit, and then we went through all of this for our matter. Actually, it becomes incredibly cost prohibitive and tech prohibitive, because you can run a lot less technology off a small unit than you can if you forensics lab. And it's very interesting in practice when that's put in front of the client. Then it seems like their appetite for data privacy compliance, let's say, is not as strong as it maybe was at the beginning. And then often as the controller, they're happy to go with interrogation, or maybe come with a hybrid where you'll do a PII review in country, and then you'll export on the basis that the rest of it will be relevant proceedings. I guess my question was around where investigation fits, because I don't think it fits narrowly with the definition of the legal process.
So just very quickly, the other thing to bear in mind is often statutes. So we have some jurisdictions like Switzerland and France, where we have experience in a straightforward criminal investigation where you simply cannot, even if you wanted to, voluntarily transfer data sort of delivering up to our authorities in the UK. And that's straightforward when you've got a criminal investigation. I think there is now a grey area where it comes to things like, for example, self-reporting. And when you're conducting what begins as an internal investigation, it's always this significant what might be doing internal that to an enforcement agency. I think we just need to make sure we're pausing and saying, actually, might be before by what statute, might be before by budget ground, once the person's touched on, because otherwise we can get it particularly quickly. And of course, they have criminal sanctions if we fall down, so big stake.
It's actually mindful that we do some work in China where you have state secrets, then you have data privacy regime that hasn't really been tested. And again, there, you don't want to fall foul of criminal sanctions. And, we have to look at this on a fairly regular basis. Yesterday we were talking about Saudi, where the law is in place, but the implementation of the law isn't. And so, you just have to be very careful. And I think organizations are becoming much more sophisticated when it comes to data privacy. And so often, particularly if they are the controller of their own data, it's really good to engage them very early on that and see what their appetite is. So, I mean, this leads pretty nicely into our case. The last thing I'd say, actually, when you're talking about technologist review and things like that, and getting to the smaller second, 500,000. So if we have our own generative AI, which we're not using outside the organisation yet, but what we think the next step is, and we actually have a full time about this, is once you get to that smaller set of what you know are relevant documents because you've tested the stuff, the outliers, actually with some good prompt engineering, you can probably spit out off the back of the relevant documents that you've identified using human and tar, a fairly robust report. And so, again, there will be a draft report that you can look at, but it would be automatically hyperlinked back to the documents it's referring to, which again moves the needle fairly significantly from manually reviewing stuff. So this is going to be, that's not working. I might just
Sure. Tool is currently in but can you get it to produce it in a consistent way? So obviously, if you have a team of counsel, paralegals, everyone might have one way of doing it. Will the way in that produces it? It'll be the same every time, so you fit whatever criteria you need to do, and it will then summarise it in a specific way, so the person analysing it doesn't have to.
I think it will very much be driven by the instruction. And so we've been using this stuff in the background for things like summarising court transcripts, for example. So you're kind of using natural language processing for query, but something like that, you're using like large language models, which is what ChatGPT uses. I think this is really what we're going to be talking about this afternoon, is how we do that, but where does that come from? A lot of it will come from lawyers. as you say, the format of it, the way that the information comes out. But it's just going to be a learning curve for everyone. And the reason we haven't been deploying it in a client-facing way is just because we're still not convinced that there are organisations that have banned it, so banks like JP have banned the use of it. There are countries like Italy. I mean, there are some of the countries you'd expect to ban it. Italy banned it, I think, 3 weeks ago, and they were back on their ban. I think banning technologies are very, very slippery slope, but it just shows that there are some dangers to it, especially when you can't immediately tell what has been generated by AI and what humans have. We did this exercise a few weeks ago where we used it for some of our sales teams. We're using a very high quality data to build outreach, and actually no one can tell the difference between what a human has written and what's been spat out. I mean, the question was then, what's the point of all the jobs? I know we're kind of running short on time, but this is just one of the things that we've worked on together. It was an investigation service payments. We did some advisory work on the collection of data because there are certain data privacy elements to consider. We didn't do the collection ourselves, but the organisation had these specific internal set up. So they were able to do it just with some guidance from us, even if you're collecting at the back end of Office 365, which everyone thinks is very safe to do. There are probably 10 different things that go wrong if you're running that collection on your infrastructure. So just kind of hand-holding that piece of it. And then reporting on things like dates and sentiment and custodians, so that very quickly, even though it's 35,000 documents, which is only 7 gigabytes, you can see probably in less than half an hour, like a dynamic visualization of what that data looks like. I'm actually thinking I might just go to the tool quickly because we are running out of time. So let's see if this play is going to be an interesting one. There we go. Watch helping again. But what it very quickly gives you a snapshot of the data, so you can see who was emailing when, what time frames look like, things like 0 day analysis. So if someone averages 50 emails a day, why on one specific day do they have no emails, or conversely, do they have 150 emails when they wouldn't normally do that? And so it gives you oversight into a data set that you just wouldn't be able to get by reading all the documents yourself. And what that then leads you to is the ability to actually run some conceptual analytics on that to help with investigations. What we've consistently found is that the hardest part of all this is that in investigation, you might move on to the next one. Yeah, you can play that. What you're looking for unknowns to help with your investigation. No one's going to preaching to the choir. No one's going to say, "Hey, I'm write an email from their work email address saying I'm going to perpetrate fraud tomorrow." If they do, then it makes life very easy. And so you're kind of, this is just a dashboard that looks at, gives you data insight. The important part of this is you can use those insights to seed any of the analytics. So if you find something that is of interest to you, whether it's a word or a name or a person, you can use that to just run a search that brings anything substantive similar back. The unknowns piece for this is it's not even really AI, it's conceptual clustering. So we'll just find words that appear proximate to each other on a regular basis. The more proximate they are, the more they appear, the higher likelihood is that they're conceptually similar. And so you're likely to find in amongst loads of terms, the typical use cases, you find those terms that you know should appear together, and then something that doesn't make sense in that grouping, and you can investigate that quickly. And so this is the cluster wheel. This is where a lot of the tech like relativity and digital reach, which are proprietary tools, a lot of that stuff kind of looks a bit samey and a bit boring, to be honest. But this kind of starts looking a bit sexy and a bit more like what legal tech should look like. And so you can use this to keep identifying more and more concepts that you don't know about at the outset. The next one, which should be coming up pretty quickly, is comms analysis. And so even though this is only around 30,000 documents, which is not that many, you can see in a way that you just can't render by doing a manual review, who's talking to and when, and you can drill down into that. So if there are people that shouldn't be talking to each other or strange that they were, then you can see that pretty quickly. You can also see one interesting thing is the way you come up with different identifiers for people. So someone should be using their work email address, but even if there's one instance where someone's used Quentin Newcomb at gmail.com, that will be flagged and it'll be part of their identity. And then all of a sudden, if you see that dark email is being used to transfer information, that usually gives you some good insight. And then all of this stuff gets seeded into, Quentin mentioned TAR and continuous active learning, gets seeded into that. And so it finds things that are substantially similar that would be material to the investigation. As you review it in real time, it prioritizes it. And so typically what happens is you'll only really look at 10%. So I think in the one that we had before, there are about 3,500 documents out of 35,000. And then you test what's remaining to make sure that there's nothing that's missed. And then obviously that's what can be fed into the next iteration of this generated AI. I know we're 1 minute over 2 minutes over, so I'll pause on that. The only thing that is just looking for 1 minute of all the mobile data, phones, geolocation. But I'll pause for you to speak.
Yeah, any questions or comments on that? Or should we move on to the next section?
Or
It's not true. There's a brief section, I think that's
sure. Yeah, that's fine. And so with the most common data source that we have now is mobile phones. And so they're just fraught with danger of missing information. The first one is actually just very practical. It's hard to look at a mobile phone chat in kind of existing tech tools right now, where you're used to seeing it in kind of bubbles. And so that's the first thing that we do. We render it in bubbles, and it's important because you can then see a chat as one document, or you can see each part of the chat as a separate document, and then you can build different analytics off the back of that. This then you have things like media on WhatsApp. We have one matter where people are just taking pictures of documents and sending them. Maybe we do that, but they're taking pictures of documents and sending them across. You don't collect the media, which some people don't want to because it's just much bigger and more expensive. You can miss stuff like that, and audio notes that go back and forth. But even on phones update so quickly. It's almost like cops and robbers. What our forensics team's doing is they're trying to break encrypted phones that the makers of those phones and tools don't want them to do. And so they're continuously updating scripts. We're on the other side of something where they missed the update on the script. And so, and the dates were getting inversed on the update, which was going from the US day and time format to the UK. And so actually their entire data collection missed any WhatsApps after the 12th day of the month, which is fairly problematic. And then when you get further into the phones, we started for investigations particularly using geolocation. So, there so much of what happens on your mobile phone has that tag on it, and you can just render it in the viewer, so you can see where someone was at any given moment in time, which can be very powerful. And then there and that applies to things like pictures, videos. And so a phone is, if you can get, phones are notoriously hard to get hold of, particularly where you're at. But if you do get hold of them, they're usually gold mine. I think I saw yesterday that various people from the SFO are going to put their phones up, which is going to be very interesting for everyone but the SFO. And so, it was just that, because I know that's kind of a real pain point for my clients. That's only I have to say.
Thank you very much. Yeah, absolutely. So I was going to touch on the last point about blurring the boundaries between personal devices and work devices and where we look at their business. Just put into staff really in the key IC case recently out and say that on the legal side of things is really interesting, I think, and underlines the importance of internal approaches to whether there are business and what format and what might be acceptable disclosure in due course. Just final thought, we very often, certainly in our world as commercial crime, you can be quite complacent perhaps, and then think perhaps the regulators and enforcement agencies are way behind us when it comes to the use of technology. I think if you just look at recent events, there have been all kinds of stories about the sorts of data that enforcement agencies are now used to handling. So Rolls-Royce, 30 million documents, Airbus are not the same. And since 2018, at least, the SMO have been leveraging this kind of technology in the software and this kind of systems they're using. So OpenText SMO, I think, is the software they're using, and they're due to have all of their cases transferred onto that by the autumn. So to the extent we feel any complacency and that we're ahead of the game, I think it's worth companies and others being aware that actually law enforcement have now an increasingly significant body of threats using this material. And if we're not leveraging this technology appropriately, then we may be the ones who are getting a step behind the curve. So I think that's just worth bearing in mind. But with that, on behalf of Shiv, Kirsten, and the Fieldfisher Global Investigations Team, a big thank you to Al and the TransPerfect team for today. Thank you all for attending. Please do hang around for a cuppa and continue the conversation afterwards. And to those online, regretfully, we'll say goodbye to you here, but do get in touch if you want to follow the conversation up. So thanks all very much. Yes.